USCIS denied a CSPA case. We filed a motion to reconsider, meaning, officer, I think you got it wrong. I think you're mistaken. Please take a look at the file and approve the case, please. And then we got it reconsidered and approved. Let's go through everything. This is a great story. Hi everyone, my name is Joseph. I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. So the legal problem is that this doctorate student on an F1 visa was here in the United States studying. The mother's here on a green card, and the son was here studying as an F1 student, being a doctor. The mother got a green card for so long, became a citizen. And as a citizen, she filed a new I-130 petition for his son, but then freaked out. Why? Because now there's immigrant intent, and he was still an F1 student, so they withdrew the I-130. And then after that, the new CSPA law came out last year, and they found out about it. They contacted our firm, and we said, no problem, we can file the case for you. We're able to freeze your age under 21 years old, so your son could get a green card. They said, great, we trust you, let's go. We filed it. Without a request for evidence, the case was denied. We prepared a motion to reconsider and said, nope, we think USCIS got it wrong here. We'll fight this for you. Prepared it, filed it, and the case is approved. We were able to use the dates of filing chart, froze it back to May 2019. This is the complicated part. This is the part where the new law comes in, allowing us to do that. But long story short, we were able to use the dates of filing, freeze it at May 2019, which means he was 23 years old, and 232 days. Well, that's still over 21. But then we used the traditional CSPA law, and the pending period of I-130 was 2 years and 268 days. You're fast at math, you can come to the conclusion. We were able to freeze his age at 20 years old and a little bit over 300 days. Now, what did USCIS do that they calculated it incorrectly? They looked at the case and they just simply denied it. They just simply denied it. And they said, you know, you had an I-130 petition and you withdrew the I-130 petition, and so we're denying your case. Yes, the client withdrew the I-130, but they have two I-130s. You know, the top I-130 was withdrawn. You just needed to flip a page to see the second I-130. In fact, in our original filing packet, we included the correct I-130. We didn't even include the other I-130. And that just shows, again, USCIS officers, CBP officers, the consulate officers, their first priority is not to look at your filing package. Their first priority is to look at their own system to see what's there. If they looked at our immigration package, the cover letter, the forms, the attorney brief, the CSPA calculations, the exhibits, everything was laid out super clearly. So we requested this officer to do a motion to reconsider, to reopen it. Now, this officer who got the motion to reconsider is the same officer that denied the case. But now, if he does not approve it, if he wants to deny it, it has to go to his supervisor. And if it has to go to his supervisor, then his supervisor would have known, and then it would look really bad. We laid out the facts, 2-3 pages. The legal analysis was a page and a half, and then calculating a CSPA from our original attorney brief was another 2-3 pages. Provided 7 exhibits of all the things that are relevant. Again, it's a motion to reconsider, so we're not providing anything new. We're just laying it out very clearly for the officer to review. I personally think we overkilled this case, but you never know what the outcome is. And so we had the time, we wanted to focus on it, and we wanted the client to know that we didn't do them any wrong. Because from the client's perspective, think about it. Previously, green card was denied because CSPA didn't apply to him. Back then, we didn't have that many success. We probably had like maybe 5, 7 success cases on CSPA. Now we have like over 50, going to 75, you know, but nobody did it at the time. So they put complete faith and trust in us. And then USCIS denies it. One reason why we did the brief is to show conclusively that we were not wrong. And also, hopefully this USCIS officer learns so he doesn't make a mistake for other clients, because, you know, God forbid. Luckily, this client was with us. We were able to file the case and we were able to win it. What if some poor soul filed the case at the same time, but got the denial and just gives up? And they could have gotten a green card, but they didn't because USCIS didn't know or they didn't know. That would be such a tragic story, you know? So I'm glad we were able to do a good service for the government, give them the training, and help our clients win. So if you have any questions, Rebecca did this case. Rebecca pulled through. I'm very happy for what she's able to do. If you have any questions, feel free to reach out to us. Rebecca could talk to you about this case. Take care. Bye-bye.